Yes.
Isn't it true that you told him that that he was involved in an accident with this woman? Do you recall that?
I don't recall.
Do you recall telling him that there was evidence to show that he actually did point the gun at her
Yes.
from a video camera?
That's right.
Do you have any evidence of it?
No, sir.
So you lied to him about it.
Yes, sir.
And is it your practice to lie?
Objection, he's allowed to lie.
The trooper told a suspect there was video proof he'd pointed a gun. There was no such video. He'd admit that under oath just a few minutes later. Let's back up to how this started. In a Michigan district court, Judge Oakley presided over the preliminary examination of Jeremy Taylor, charged with felonious assault and a mandatory 2-year felony firearm enhancement following an alleged road rage incident on I-2005 near New Boston. The prosecution's first witness was Elizabeth Worrell, a logistics worker who testified.
State your name for us.
Elizabeth Worrell,
How do you spell your last name?
Worrell.
And Elizabeth as in Queen Elizabeth?
Yes.
What do you do for work?
I work at a logistics company out in New Boston.
Taking you back in time to April 23 of this year, 2025, at about 6 in the morning. Do you recall your whereabouts?
I was on my way to work on 675, coming up to my exit, to get to work.
What type of vehicle were you driving?
I drive like a Santa Stray, Chevy Trailblazer.
Are you alone in the vehicle or do you have company?
No, I was like, so.
You started telling the judge about you on I-75 North.
She was driving to work around 5:30 in the morning when a dark-colored Chevy Malibu began tailgating her, then pulled alongside her vehicle.
Anything unusual happened to you when you were traveling on I-275 North?
I was on my way to work that morning and I noticed that there was a vehicle behind me. The vehicle was very close to the, rear of my car. I had changed lanes a few different times. If I'm not mistaken, I changed lanes a total of 4 times.
Tell us about the weather. Was it light out or dark?
It was typical, nighttime, right before the sun was coming up, it's about 5:30 in the morning.
Are you able, so that's all interrupt just because we can't hear it, yes. You know it's fine. Are you able to tell the judge the color of the other vehicle?
Yes.
What's it called?
It was like a dark gray, dark blue.
Are you able to inform the court the model of the vehicle?
Yeah, it was a Chevy Malibu, license plate was the first EJY.
How do you know the license plate was showing EJY?
Because as he was speeding away from me, as I exited onto my exit to get off for work, he said past me at probably about 100 miles an hour. And I caught the first real license plate and the description of the vehicle.
She said she saw the outline of a handgun pointed at her from about 7 feet away.
Anything happen when that vehicle pulled next to you?
I saw the outline of a handgun pointed at me.
How far were you from the person holding the handgun?
The vehicle had moved right next to me in that lane, so.
Can you give us an estimate on the distance? I'm gonna walk towards you with the judge's permission. Can you stop me when I reach that distance?
Probably about right there.
Judge, may the record reflect about, I know I'm short, but about 7 feet.
Mr. Weinberg?
She caught a partial plate. The first 3 characters EJ. She never saw the driver's face. Too dark, she said. Just an outline.
What do you do after the gun's pointed at you? Do you contact authorities in some way?
I had pulled in
Sorry.
You're all right.
I had pulled into work, contacted my wife and, let her know what happened. She told me that with.
Can't tell us what she said.
Okay.
But anyway, you contacted
So-
your wife.
Yep, I contacted my wife. I ended up leaving work and, at the end of the road that I work off of, there was a New Boston police officer.
Did you have contact with the officer?
Yes, I pulled up next to the officer, explained what happened and asked what I do moving forward. And then that's when, we took my statement and this all began.
Are you able to identify the man with the gun?
Yeah.
Why not?
It was too dark, I couldn't see the face. The only thing I could see was the outline.
Hey, Brandon.
Now, an outline is doing a lot of work in this case, because that's the entire identification the state is working with. On cross-examination, defense counsel pressed exactly where you'd expect. Could she identify the defendant in the courtroom? No.
Sir, you stand. Sir, can you identify that man at the table? You cannot identify my client, Mr. Jeremy Taylor, is that correct?
Objection's been asked today,
Is that correct? You can't.
it's been an objection asked.
Clarification.
So you have no idea whether or not Mr. Taylor was the man you're talking about that day, correct?
No.
Correct. And it was too dark to identify him, is that correct? What kind of day was it?
5:30 roughly in the morning.
5:30 in the morning, so it was dark. And when do you claim that he actually pulled up next to you was the light in his vehicle?
No, the lights on the, other side of the freeway, that's how I could see the backs of the line, but I could not see
Okay.
his face.
Did she hear his voice? No. Could she describe the gun's make or model? No.
Okay. So you didn't see a gun, you saw the outline of the gun, correct?
Right.
You can't identify the gun, correct? Can't identify the model or make, correct? You saw an outline of what you thought was a gun, correct?
Of what was gun is.
Well, did you ever touch that gun?
No.
And you can't identify anything other than the outline, correct?
Right.
Have you ever seen a gun close up before?
Yes.
Okay, do you own it? Do you own a gun?
No, I do not.
Okay. You ever seen the outline of a handgun like this gun before?
To me, handguns for the most part look the
Right.
same.
Did you understand the question?
Yes.
My question was, did you ever see an outline of that specific gun before?
I can't answer that.
Was that a yes or no?
Just an outline at highway speed in low light.
That morning, did you make a statement to the police?
Yes.
And again, did you tell them at that time that you could not identify the man or the person who allegedly pointed a gun at you?
Yes.
Okay. And did you ever tell the police that you heard this man say anything?
Oh,
So you can't identify his voice either, is that correct?
correct.
You can't identify anything other than you saw the outline of what you think was a gun, correct?
Correct.
I go with
Here's the legal reality worth sitting with before we go further at a preliminary exam. The state doesn't need proof beyond a reasonable doubt. It needs probable cause, a far lower bar. That gap between what gets a case to trial and what actually wins at trial is the entire reason cases like this survive an early hearing even when the eyewitness testimony is this thin. The state's second witness was the trooper who located Taylor using that partial plate and a license plate, reader camera search, then conducted the traffic stop.
How did that,
Traffic stop was conducted,
by who?
I did. And I pulled him over on 275 near Eureka. Spoke to him briefly, introduced myself, asked him if there were, or he declared to me rather, I didn't have to ask, he declared to me that there was a firearm in the vehicle, that he was a CPL holder. Shortly thereafter, I read him his Miranda rights, took him into custody.
He testified in a straightforward, practiced manner about how many times he'd read Miranda rights over his career. Several hundred, he estimated, and confirmed he read Taylor his rights before any real interrogation occurred.
So don't go any further.
Yes, sir.
There was the Miranda rights.
Yes,
When prizing with such rights, did you do so from your memory or from a form?
that's read to him from a form. I read it to him from a form.
Can you estimate for Judge Oakley the number of times you've read Miranda rights to suspects?
I would say, fair estimate would be several hundred.
Small detail, low stakes. But it's the first thread defense counsel starts pulling, because things get more serious fast. On cross, the trooper was asked directly, did he tell Taylor there was video evidence showing him point a gun at Worrell? That's right, he said. Did that video exist? No, sir. So you lied to him? Yes, sir. That's the moment. Not a hypothetical, not a gotcha built from paperwork discrepancies. A sworn admission in open court that he fabricated evidence during an interrogation to pressure a suspect into confessing.
Isn't it true that you told him that that he was involved in an accident with this woman? Do you recall that?
I don't recall.
Do you recall telling him that there was evidence to show that he actually did point the gun at her
Yes.
from a video camera?
That's right.
Do you have any evidence of it?
No, sir.
So you lied to him about it.
Yes, sir.
And is it your practice to lie?
Objection. Objection, he's allowed to lie.
Well, I'm asking you.
He can be Pinocchio, it doesn't matter. He can say whatever he wants.
I understand that, and I agree with you, but that doesn't mean Mr. Weinberg can't ask me questions about it.
Yeah.
So is it your practice to lie to a suspect during the investigation?
We object to that question. It doesn't matter what his practice is. It could have been the first time he lied, or he lies all the time. It's not relevant.
That would be an irrelevant. Go ahead. Relevance objection.
It's not only relevant, rather, it's also goes to his experience and his practice as a trooper. The prosecutor went into excruciating detail about how many types of stops he had, whether or not he's had gun types of investigations, whether or not he loaded, how he knows is it practical to have something on his hip if it's holstered or not. I'm just going by his practice in terms of interviewing witnesses.
You're stretching, but I'll allow it.
So is it your practice to lie to a suspect while you're doing an investigation?
It's not necessarily my practice, no, sir.
But you chose to do it in this.
Yes.
Here's why that matters legally, and it's a real distinction. Not just a talking point. Courts have long permitted officers to use deception during interrogation. Telling a suspect there's evidence that doesn't exist isn't automatically illegal. But it does something specific here. It explains why Taylor's story shifted the way it did. He initially denied any road rage incident that morning.
I asked if there was any unusual road rage type incidents that had occurred then.
What did Mr. Taylor say in response?
Initially, he denied that there was, saying that something had happened the day prior.
You said initially.
He did, that's right.
What does that mean?
So when I first asked that question, had anything unusual like a road rage incident happened, he said, no, not this morning. Yesterday, something happened between me and a female in a light colored vehicle.
Does he give a different answer at some point?
Then said maybe it happened. Then said he might have pointed his finger. Then said he might have been holding a coffee mug.
Goes on to describe the victim's vehicle and somewhat of a road rage interaction between them.
Did he indicate to you any specific actions he claimed that the other woman took?
To my memory, that she brake checked them and flipped them off,
What is flipping off?
presenting her middle finger to him. A derogatory manner.
Did you specifically ask him whether he pointed a gun at another moment?
I did, yes.
What did he say?
He denied this.
Does he later give an explanation?
He does.
What does he say?
He said that it
Once you know he was told fake video evidence existed, that shifting story reads less like the story of a guilty man getting caught, and more like the story of a man reacting to being lied to. The defense didn't stop there. And here's where the biggest contradiction was still ahead of us. Because the trooper had also testified that the recovered firearm was loaded and readily accessible.
He claimed his vehicle. Does that match or not match the vehicle you saw in front of you?
does.
How does it match?
The first three of the license plate match, and also she described the color and model of vehicle along with bumper stickers stretching from one tail light to the other across the
If
back.
those coincide or not coincide with the vehicle, you know.
Those all coincide.
What happened to the gun?
The gun was seized from the scene of a traffic stop and put into property at the Metro South Post.
Are you familiar with the term holstered gun?
Yes,
Gun being holstered?
yes.
What does that term mean?
That means secured in a holster for carrying the firearm.
When you recovered the gun from the center console, was it holstered or unholstered?
I do not recall.
Would your report refresh your memory?
Yes,
Do you have your report with you?
I do not.
Judge, do I have permission to approach the witness and have him review his report?
Sure.
Thank you, Your Honor. Read it yourself, Trooper Meyer. Thank you.
Thank you.
I didn't underline this. I don't know any specific page.
Understood.
That's the law. Oh, I'm sorry. Have you had a chance to read
I
the
did.
report?
Yes.
Judge, do I have permission to retrieve the document?
You do.
Just remember the document. You don't get anything critical. Hold it. What does your memory tell?
That in fact, the firearm was in the center console unholstered.
Was the firearm loaded or unloaded?
It was loaded, magazine full.
If you investigated shootings in your career,
I have this.
tell the judge, and probably knows, a gun, which is more readily usable, a gun that is holstered or a gun that is unholstered?
Unholstered.
Pressed on the details. He admitted he didn't personally recall whether the gun was holstered when it was found in the center console. He needed his own written report to refresh his memory.
Yes.
What does that term mean?
That means secured in a holster for carrying the firearm.
When you recovered the gun from the center console, was it holstered or unholstered?
I do not recall.
Would your report refresh your memory?
Yes,
Do you have your report with you?
I do not.
Judge, do I have permission to approach the witness and have him review his report?
Sure.
Thank you, Your Honor.
Defense counsel asked whether he'd personally verified the loaded status himself. He hadn't. He was told it was loaded, he said, but couldn't recall by whom. A gun that's holstered and a gun that's readily accessible are not the same thing under the law, and the trooper's own uncertainty on that point undercuts the very testimony the prosecution needed to establish the danger element of the charge. The judge herself interjected at one point during the deception line of questioning, asking whether the discrepancy was material to probable cause or whether defense counsel was litigating a suppression motion early.
I have do you recall whether or not your squad car had a video on the set?
It does, yes.
And do you recall whether that recorded any of your conversation with my client in your vehicle?
Yes.
And you recall whether or not, had you reviewed that movie?
It's been some time. I reviewed it either that day or that week.
But it's your sworn testimony that prior to interviewing my client in that vehicle or outside the vehicle or any time that day that you read his Miranda.
Counsel's response. It goes to credibility. Bear with me. It gets more relevant. It did. By closing arguments, the defense laid it out plainly: no identification of the defendant, no photograph of any gun, no independent verification of the weapon's condition, and a lead investigator who'd already admitted under oath to fabricating evidence during questioning. They better have more than she could be mistaken. Defense counsel argued. They don't even have the facts.
Thank you, Judge. Well, I will go by a much better prosecutor than I might be as a defense attorney, but it can't just be, he could be mistaken. This man is charged with a 4-year felony and a mandatory 2-year felony firearm. They better have more than simply, she could be mistaken. She did not identify a gun. They had no pictures of a gun. They never identified any gun that she identified. They never had any evidence saying, yes, that's the gun that was used, or this is what the gun looked like. It was an outline of a gun where she readily admitted it was too dark even to identify my client. It was at 5-something in the morning. There's no lights up, maybe some street.
Judge Oakley's response is the line worth remembering. She said she didn't see, anyway in hell, a jury convicts on this record, and then bound the case over anyway, because the probable cause standard, low as it is, had technically been met.
And reviewing, the start night, but in reviewing the case, you're determining whether there's probable cause to believe the crime occurred, and there's more than probable cause here. Thank you.
I don't see any way in hell of getting a conviction, but the probable cause burden has been met. I'm tempted to dismiss it just so we don't waste any more judicial resources, but that's not my role. I'm going to bind it over.
Thank you. Thank you.
AOI is October 29. October 29, 9 a.m. Bond will continue. Good luck downtown, gentlemen.
Thank you. It's not a
That's the gun video lie we opened with. A trooper admitted, without hesitation, that he told a suspect there was footage that didn't exist. And it took less than a minute of cross-examination to get him there. Let us know in the comments what you think happens at trial, and subscribe if you want to see how this one plays out.